Welcome to Leveraging Inspiration, the Inspired Patent Podcast, where we help you understand and leverage your intellectual property. I'm your host, Wayne Carroll, and I'm excited to bring you insights and stories from the success and failures of others and teach you how to win at the game of intellectual property. I always start with a disclaimer. The information I provide on this podcast is for educational and informational purposes only. I am not providing legal advice, and nothing in this podcast should be construed as creating an attorney-client relationship. Today, we're talking about, in this episode, the role of contracts in IP ownership, navigating joint ownership, licenses, and assignments to protect your interest. A well-drafted contract is like a compass that guides you through the intricate maze of, in this case, intellectual property ownership. In our last episode, we discussed the defaults for IP ownership. In this episode, we'll go deeper into the issues and share the strategies for structuring your contracts and relationships around intellectual property. So intellectual property is a valuable asset for small businesses. If you missed episode 1, I discussed that your intellectual property is the invention, not the patent, the goodwill in your brand, not the trademark, not the registration for the trademark. So go back and listen to that one if you missed it. Without proper protection, that property can lose its value. Contracts are the first crucial step in IP ownership. Without proper contracts, businesses may face disputes, loss of control over their intellectual property, and certainly missed opportunities for monetization. As we discussed in the last episode, if a company is litigating, spending a lot of effort and time and money to fight over intellectual property, they can't use that money to create new innovations and focus on growing the business. Sometimes it's a necessary evil, but whenever we can, we want to help you avoid that. Some of the things that we want to talk about is joint ownership. So joint ownership doesn't really work out very well. It's kind of bad for business. There's they call it the tragedy of the commons, or where, it's great to say, well, let's let everybody own everything. That doesn't actually work out. Somebody needs to be responsible. Somebody needs to be driving forward. When multiple parties contribute to the creation of intellectual property, if you don't have the proper agreements in place, what you end up with is joint ownership. And as I said, that usually doesn't work out very well. So one entity needs to own and control intellectual property to maximize its value. Licensing is another possibility for monetizing, and you want your agreements. As I said in an earlier episode this week, look at your goals. Is it a good potential for your business to license the intellectual property you have? Sometimes people think, well, I don't want to enable my competitors to compete with me. Sometimes your innovations, you can step back and look and say, this innovation we've come up with, is there somebody who's not competing with us, a market that we're not in, that could benefit from our innovations? If so, that's a perfect opportunity to license that technology. You can limit that license to the field where they are and keep them out of your space. They may be very happy to gain your knowledge, your insights, your innovation, and be able to leverage that in their market, in their technology. So that's sometimes some good opportunities, and a lot of those opportunities are missed because people aren't looking for them. What is an assignment? That's another way that's going to be an important part of contracts, is when the assignment comes in, especially when you have people that you're paying to create intellectual property. Since the defaults too many times don't give you the ownership of that intellectual property, you have an agreement ahead of time that says you are going to assign that intellectual property to me. That's part of the deal. That's part of what we're doing. If you don't like that deal, let's, not go forward. If, there's assignments, that means one person's going to own it, which is different from the person who created it. Contracts play a vital role in protecting your intellectual property. those contracts need to be clear and understood so that everybody can comply with it. And one of the challenges with contracts is they often have too much of what's called legalese, legal language, and a lot of it's not necessary. The therefore and said this and said that, those aren't necessary at all. There's no legal reason why you can't say yes, it's good to define terms, and that's often helpful, and that's done in a lot of contracts. It says when we say this in this contract, this is what we mean, and then use that term consistently, and that helps a contract be clear. So a contract is really designed to set up a relationship, and the contract needs to reflect that relationship. There's a lot of relationships that you can figure out how you're going to do it. If you're in control, you're the employee or you're the person hiring the contractor, you can say, well, these are my terms. If you want to work with me, here's my agreement. And as long as you have people that are willing to accept that on your terms, that works great. If sometimes, though, you need something specialized and you have very limited people you can go to for it. And in those cases, you may have to negotiate those terms. You may have to clarify. And as I said in the last episode, you don't want the terms to look like you're greedy. You want it to be fair. You want everybody to profit from the agreement. And profit, the broad term is you get more out of it than what you put into it. And everybody can do that, because more for one person is money, more for another person is time. And so people can exchange and they can all have more of what they want. And agreements do not have to be a zero-sum game. You win, I lose. That's actually a bad start of a relationship, is to have an agreement where it feels like if I sign this, I lose. And sometimes in lawsuits, that's a settlement, as you feel like, well, I'm kind of losing, but, it's going to be over with. So let's just get this done. And that's not the type of agreement we're talking about. We're talking about the agreement where you're building a relationship with this agreement. You want everybody to see themselves as winning. And like when you hire a great employee, you win and they win. If they actually turn out to be the great employee you were hoping, and you're able to compensate them the way that they want to be compensated for working for you. So some of the things to do is, when you are building your intellectual property, consult with professionals. Get guidance from an intellectual property attorney like myself, who can help you understand what are the details of the contracts, what are the key things. And the attorney isn't necessarily going to have all the answers. The attorney is going to should ask you, how would you like this to be? What does winning look like for you? And let's put that into an agreement. And make sure everybody understands the agreement. In a previous episode, I talked about Sears having bought a patent from one of their employees who wasn't hired to invent anything. And he afterwards felt like he was taken advantage of. And in one of the things that they could have done, and cases like this, people look back and say, how could we do it better? How could we avoid this result? And if you have a situation like that where somebody who it's not in their job description at all to invent something, they come to you and say, hey, I invented this, and you don't have agreements that say, if you invent anything related to this company, then we get that. And that doesn't always make sense. So some of the things they could have done, and hindsight's 2020, so I'm not, trying to beat anybody up here. They could have insisted that he get his own attorney. That probably would have saved them a lawsuit, because and they may even said, tell you what, we're going to give you, enough money for you to hire an attorney just for us to evaluate this, because we think it's valuable. Back then that might have been $1,000. They got the deal done for $10,000, but then they paid a ton of money to attorneys, and there was a ton of costs for trying to get that deal for just $10,000. So go back and listen to that if you missed that. And so insisting that somebody has their own attorney helps put them on the same playing field, and doesn't allow, and it may seem like counterintuitive of, well, since I'm negotiating against somebody, why would I tell them to get more strength? It's because if you don't, then things are going to be construed against you. It's easier for them to paint you as the bully in court. And if you showed, hey, we were trying hard to work fair, we told them to get an attorney, they said, I don't want an attorney. We had them put in writing, we gave you an opportunity to get an attorney, and they still didn't get an attorney. Then it's going to be harder for the court to say, were you really bullying? Should we undo this agreement? Should there be damages in their favor? So thank you for joining me this week. Next week, we are talking about trade secrets in more detail, whether to get a trade secret, keep it as a trade secret or patent. What is an NDA? What do you need more than an NDA? So thank you for joining me. This is Wayne Carroll with Leveraging Inspiration.
At what point do you have an MVP? At what point do you have a product to take to market? But perhaps in the particular context of aviation,